Hello and welcome back. My name is Thomas Lundmark, and you are watching my tutorial on the features of common law and civil law systems. Today I'm going to give you a short historical introduction. Before the Norman invasion, law in England was oral and customary. Sometimes there were significant regional differences, and law was administered locally. The Normans sought to establish a strong centralized government with uniform law, centrally administered, to augment and to a certain extent to replace local customary law. To centralize the administration of the law, King Henry II in 1166 sent out 2 members of his court to enforce his new inheritance law. Later, he appointed 20 to 30 itinerant judges to serve in 6 circuits, that is, regions. In this period, the judges' most important tasks were to maintain the peace and to decide cases relating to property. In 1234, 2 local courts were established in London for matters which did not directly involve the sovereign. They were the King's Bench and the Common Bench. These courts applied law that was common to the whole country, thus the nomenclature common law. The King's Courts only enjoyed jurisdiction to decide cases brought by writ. The writs were issued by chancery clerks in various forms of pleading or actions. Subject matter areas not covered by an action, like family law, canon law, and local law, were outside the purview of the common law. By the end of Henry II's reign, there were 75 such stereotyped forms of action, each with its own title indicating its function. Now, the writs employed very abstract or general language. This left considerable room for interpretation by the judges, in the same way that abstract statutes leave room for interpretation. Now, judges at the time were understood to be discovering, declaring, and applying the law, not making it. However, judicial rulings were the most reliable evidence of what the law actually was. We come now to the reception of Roman law. By reception, we mean the effects of the rediscovery in 1070 of the Corpus Juris Civilis of the Roman Emperor Justinian on the law and legal culture of most of continental Europe. This includes on the establishment of universities and on the education of lawyers, topics that we'll be discussing later. There was no reception in England or in the Nordic countries. I'll come back to that topic. Why did much of continental Europe receive Roman law? Roman law offered a self-contained private law legal system that was seen as being politically neutral. It also offered the advantage of being shared beyond national borders. Later, as continental European states began to codify their private law, they used the Corpus Juris Civilis as their basis. Thus, Roman law in large part influenced the structure, thinking, and essential terminology of the legal systems of continental Europe. This should not be interpreted to mean that the reception of Roman law was uniform. It was not. I'll show this on the example of France and Germany. In 15th and 16th century France, the Parlement, which were independent courts, applied the Roman origin jus commune in preference to custom, alongside a widespread adoption of Roman procedure. According to the legal historian Peter Stein, Roman law in this way gradually seeped into French law. By the time of Napoleon's Code Civil, many Roman legal ideas, terms, and procedures were already in use throughout France. In the 19th century, the French Code Civil was imposed in area under French control, such as Belgium, Luxembourg, parts of Western Germany, northwestern Italy, Geneva, and Monaco. It was later exported to other European states conquered by Napoleon, such as Italy and the Netherlands. And the code is still in use today in Belgium, Luxembourg, Monaco, and of course, France. The reception of Roman law in Germany was later, but more systematic and comprehensive. Work on codification began after the establishment of the German Empire in 1871. And the German Civil Code finally came into force in the year 1900. It in turn has been copied, for example, by Japan and Turkey. The Swiss Civil Code from 1912 was influenced by both the German Civil Code and the Napoleonic Code Civil. Why was there no reception of Roman law in England? Legal historians basically cite three reasons. First, English law was already highly developed and consistent, that is, common throughout England. Second, Roman law was considered to be too closely affiliated with the Roman Catholic Church and with the Pope. And third, the reception was also seen as an attempt by English kings to place themselves above the law or outside the law, as in the Roman maxim, the will of the prince has the force of law. In summary, judges played a significant role in developing the law in England, where Roman law was not received and where codifications are not seen as being exclusive sources of law. This contrasts with the widespread reception of Roman law on the European continent that ultimately led to the enactment of the Grand Continental Codes that remain in use today. If you'd like to pursue this topic further, I recommend that you read my script for this lecture and also consult Chapter 1 of my book, Charting the Divide Between Common and Civil Law. Thank you very much.